Chairman,
Yes.
not to disagree with my fellow former Attorney General Senator Blumenthal, but since Senator Moreno mentioned it, the reason that I asked Dr. Fauci what color his tie was and what day of the week it was and what color the carpet is, he looked, by the way. I thought he was going to answer that one. He looked very carefully at the carpet, then he decided not to answer.
What we just watched was a heated fight over the Fifth Amendment, congressional oversight, and whether Dr. Fauci was using a constitutional right or avoiding the committee's questions. The moment that really stood out was Fauci refusing to answer even basic questions about his tie, the carpet, and the day of the week. The senator used those questions to argue that Fauci was making blanket use of the Fifth Amendment. But Senator Blumenthal pushed back, arguing that the real issue was whether Fauci had a reasonable fear of prosecution. So who had the stronger argument? I'm Ray, and this is Capitol Conservatives. If you want more breakdowns of heated congressional hearings, make sure you subscribe and stay tuned.
The reason I asked those questions was precisely to test the good faith nature of his invocation of the Fifth Amendment, because as the lawyers in the room will know, the invocation of the Fifth Amendment, particularly in a context where immunity has already been obtained, Dr. Fauci has full immunity, he has a full and unconditional pardon for a period of some 11 years. In that context, the assertion of a Fifth Amendment privilege only adheres to those instances where the witness has a reasonable fear of future prosecution, and it must be tailored to any such fear. And the fact that he wouldn't answer questions about the tie he was wearing or the color of the carpet or the day of the week, Senator Paul asked him about, did he have a folder in front of him? He wouldn't answer that. Betrays the fact that his invocation of the Fifth Amendment wasn't tailored to anything. It was a predetermined, premeditated design to evade this committee's questions on any subject, including emphatically those for which he has a pardon. And the United States Supreme Court has been clear for over a century, dating back to 1896, that when a witness has received immunity, he may not stand upon his privilege. And multiple courts of appeals from the United States, including the United States Supreme Court in the Castigar case, has says that, I'm going to quote now, a witness must reasonably believe that his statements could be used in criminal prosecution or could lead to other evidence that might be so used. The court has also said that the danger must be real and appreciable. It must not be one of imaginary and unsubstantial character. All that to say that I think it's pretty clear, given Dr. Fauci's 111 invocations of the Fifth Amendment, including questions that he could have no fear of prosecution on. He's not going to get prosecuted for the color of his tie. Shows that he had no interest and no intention of answering any of our questions, and that is an abuse of the privilege. There's no privilege for any of that, and I think there was no good faith attempt to invoke.
Mr. Chairman, I really need to answer with your permission that point.
Senator Blumenthal.
Whether he had a reasonable fear, I think, is beyond question. Not only the chairman of the committee, but 3 state attorneys general have said that they are conducting investigations of Dr. Fauci. The color of his tie, the color of the carpet, maybe you were testing his good faith, but the standard is not the response to your questions. It is whether he had a reasonable fear, and it is to be liberally construed, as you know, under the Supreme Court cases that you cited in favor of the potential defendant. President Trump invoked the Fifth Amendment 440 times in his deposition with the New York Attorney General. Nobody held him in contempt for doing so. This right is so fundamental that we ought to seriously consider, before we take this immensely historic step, and hear from his counsel as to what he feared, why, and how. And my motion would simply postpone consideration of this contempt motion until we hear from him.
The primary question of the hearing last week was to understand why Dr. Fauci made the decision to do this funding of this research in Wuhan. I can't understand how there could be any liability attached to a question of why. That's his opinion of why he funded it. There's not a crime in funding it. There's a judgment question.
And Mr. Chairman, there is a
we got the Fifth Amendment. All he had to do was tell the truth. The clerk will call the roll on the Blumenthal motion. I will vote no.
After watching the full exchange, the biggest issue is clear. This was not really about a tie or a carpet. It was about whether Fauci's Fifth Amendment claims were legitimate. The senator's argument was simple. The Fifth Amendment protects witnesses from answering questions that could expose them to criminal prosecution. But if Fauci refused to answer questions that clearly could not lead to prosecution, why should the committee believe every other refusal was justified? That is where Fauci's 111 invocations of the Fifth Amendment became important. The senator argued that the repeated refusals suggested Fauci had decided not to answer the committee regardless of what was being asked. Blumenthal saw it differently. Blumenthal argued that Fauci could still have a reasonable fear of prosecution because investigations involving Fauci were reportedly underway. From that perspective, the question is not whether a particular question sounds harmless. The question is whether the witness has a reasonable basis to fear that an answer could eventually be used against the witness. Blumenthal also brought up Donald Trump, noting that Trump invoked the Fifth Amendment hundreds of times during a deposition without being held in contempt. That comparison does not settle Fauci's case, but it does highlight how seriously the constitutional protection should be treated. Then the hearing returned to the bigger issue: Fauci's role in funding research connected to Wuhan. One senator argued that the committee was simply asking Fauci to explain why the research was funded. In that view, explaining a decision is not the same as admitting to a crime. And that is where this entire confrontation comes down to two competing principles. Congress has a responsibility to investigate and demand answers. But witnesses also have constitutional protections that Congress cannot simply ignore. The real question is whether Fauci's Fifth Amendment claims were narrowly tied to a legitimate fear of prosecution, or whether the privilege was being used too broadly to avoid answering the committee. That is what made this exchange so contentious, and it is ultimately what the committee has to determine.